All right, so unions ecstatic, but what will the impact on companies and jobs be? Remember, there's been a claim all along, but nobody can quantify possible numbers in terms of job losses. To discuss, we're joined by Grant Wilkinson from Coachman's Incorporated, which is the law firm that represented the labour brokers in this matter. Thank you for being with us, Mr. Wilkinson. You obviously couldn't convince the court that this is a good thing.
Yeah, thank you for having us. Yeah, look, the court outcome went against the industry, but I think it's important that one unpacks the whole outcome as a whole. There is, I saw in the media today, an interpretation that says there's a handover after 3 months. If one unpacks the outcome, it's quite clear that after 3 months, it is recognized that the transactional or the commercial relationship continues, and that the relationship, the triangular relationship between labour broker, employer, as well as the TES employee continues post 3 months. It's just providing protections, and if you look at the introduction, it speaks particularly around the Labour Relations Act, where for purposes of the Labour Relations Act, deeming occurs under the Act.
But how does that continue? Because as I understand, it used to be that those casual workers worked for the labour broker and the firm at which they were placed. Now the court has said they only work at the firm. So where does that leave the labour broker?
Well, that leaves it for purposes of the Labour Relations Act after 3 months, and again, we're dealing with employees below the threshold. So if you unpack the outcome, it talks about the fact that there's a continuation, and in fact it's one particular paragraph says that the triangular relationship continues, and that for purposes of the Basic Conditions of Employment Act, whilst the remuneration is still being paid by the TES, for purposes of the LRA, deeming occurs.
So the labour brokers are still being paid for those
the employees are still being paid by the labour broker. The Basic Conditions of Employment Act, none of the other Act has been changed by the Act.
So who provides the pension fund?
Well, that would be directly by the company or the labour broker, but the Labour Relations Act purposes, the company would be the employer, and they would be the liability. And obviously it's about the commercial arrangement then between the parties thereafter, yes.
Okay, so this is quite complicated. Does it mean that labour brokers can continue to exist if
Well, I think there will be two interpretations in the marketplace of this outcome. I've heard in the press already that NUMSA as well as SAFTU has claimed victory and say labour brokers disappear after 3 months. And no doubt that if one unpacks it, and our interpretation of it is that for purposes of the LRA, the deemed employer is the client after 3 months. But for purposes of all the other legislation, the TES is still the employer and supplies the service through to the client, through the TES.
Sure, I'm still thoroughly confused because you're saying the Labour Relations Act is one thing, but there are other laws that say there's still a relationship between that casual worker 100%. And the labour broker. Try and define it for us.
Well, the Basic Conditions of Employment Act, for instance, the employer is still the TES. The skills development levy that gets paid by the temporary employment service provider. We're dealing with Employment Equity Act.
What if someone slips down the stairs? Who's responsible?
Well, exactly.
So you're saying the brokerage?
Well, for occupational health and safety purposes, for the client, the user, because at the premises, is responsible. But for all other pieces of legislation, the TES is responsible for the outcome. So and if you look at the introduction of the outcome of the judgment, it actually particularly says that this relates to the LRA.
So your clients aren't actually that unhappy, is that what you're saying?
Well,
they still have a role to play.
They still have a role to play.
But workers are protected. Once they're in a firm for 3 months, at least they are protected, although there's still some relationship. That's all.
Well, I think there's a misconception around the temporary employment service market. It appears that the temporary employment service market has been sort of painted as this industry that abuses workers, and I think that's a misconception that has to be taken out the picture. There's a small minority, a very minuscule portion of the industry where no doubt there's an admission by all parties where there is abuses, but the largest portion of the industry actually is regulated, has their own bodies such as CAPES, APSO, amongst others, and there's regulations around ethics, etc. They comply with laws, they go through the very same process as you would in terms of assessment by the Department of Labour. So they have to comply with laws, and stringent laws at that.
What is the possible jobs impact?
It depends, because it depends on the interpretation. I think if you apply the interpretation that we have...
Do you think this will go to court again, so we can all interpret it? It sounds like that.
No, look, I think inevitably, no doubt that the process will go to court. The guys will go approach the CCMA to be made permanent, and then the debate will rage on, and it's about how it is applied. Because overall, we saw already in 2015 labour law amendments when an interpretation of transfer, and it's important that the guys take note that in the actual outcome today, it says there is no transfer of employment. and it actually explicitly says that. So where there was that misinterpretation with the 2015 amendments, we saw approximately, with the research that was done, half of the industry lose their jobs. So if you apply an interpretation such as ours, there shouldn't necessarily be job losses. You know, business continues and it's ethical business and there's compliance. But if one applies the other interpretation that is out that I've heard, you potentially could have a situation where clients have a knee-jerk reaction potentially, and due to misinterpretation or misapplication of the law, lead to job losses, as we saw in 2015.
All right, so this will still play out possibly in the courts. Thank you for giving us your take. Grant Wilkinson from Kirchmans Incorporated, representing the labour brokers in this case.